And right now we have another interesting speaker coming up. This is a topic we haven't heard from yet today, so we're excited to hear this guy. He has been a lawyer for over 20 years. He practices out of Philadelphia, but he actually works with people all over the country. Please put your hands together for the very talented Charles Riddle. Charles!
Hello, everybody. It's 4 o'clock, and I'm here to talk about trademark law, so I'm going to bore you all to death. That is my goal. Everybody should get a cup of coffee now, maybe stretch a little bit. So yeah, I mean, 20 years, it goes by fast. I started out as an intern in the late 90s, working for an intellectual property firm, you know, everybody with the suits, going to court, back and forth. They did patents, trademarks, copyrights. They did anything in that field, and it was pretty stuffy, and you know, and that's the way it is. I thought about wearing a suit today, come out here in a suit, real stiff like a lawyer, but I'm learning just kind of to take it easy, and you don't need to be that stiff. So we're talking about trademarks. Been doing it 20 years, all different kinds, all different industries. You know, it's just in my brain all the time. So we talk, we talk about it. So the first thing is, I looked it up when I was doing research for this, and we're talking about 42,000 trademarks have been filed for podcasts. So that's a lot, 42,000. I heard a fact earlier that there's something like 400,000 podcasts altogether, but 42,000 live, dead applications, registrations, that's the number. So then I looked a little deeper to see, you know, what actually, who made it to registration. There's about 17,000. So 17,000 registered names, registered logos, in the field of podcast. 2,000 of those are dead, so comes down to about 15,000 are active. So I think the number between 20 and 40,000. There's probably a lot of pending applications, because in my practice I've seen a lot of clients come in and want to register their mark. So I mean, it's out there. It's you have a name. You got a brand, you did all this work to put together your program, and you have a name, and you want to roll out with that name. I got it. Well, now what? The thing about trademarks, it's, there are things that are protectable, there are things that are not. We want to start with, what is a trademark? Well, it's something that identifies source. Sounds pretty simple. But if you call your brand the Daily Podcasts. Now, something like that is not protectable, because everyone has a right to use those terms: podcast, daily, radio, and so on. So when you think of your name, you think of it as a source identifier. It has to be something a little more than a descriptive or generic term. But it could be anything. It could be the jingle that you use. It could be the song. It could be your logo that you put up, or your name. So these are all the things. It has to qualify, it has to be able to identify your source. And like I said, it can't be just news, podcast. It's got to be something a little more. So you add something distinctive, and you try and register your mark, and you build your rights that way. I use trademark, and almost everybody does use it interchangeably, but uniformly we call it a trademark. But there's trademarks and there's service marks. So you have trademarks, which are actually for goods. There is a difference. And then you have a service mark, which is for the services you provide. So think about the swag, the Podstock shirt. That's a good. The swag you sell, those are goods. The services are what you stream, the content, podcast, news, entertainment, education. So it falls in both trademark and service mark. But for our purposes, we just call it trademarks. So how do you get them? It's pretty simple. I mean, trademarks begin when you apply the name in conjunction with the rendering of services or the sale of goods. So like today, I'm up here. My name is not prominently shown, but here it is now. So here we got esquiretrademarks.com. I'm providing a seminar in the field of intellectual property right now. I am not a registered trademark for Esquire Trademarks, but I've created common law rights just by providing the services with the name, in association with the name. Those are called common law trademarks. So that's one way you acquire trademark rights, and it's necessary in order to even get the registration. You have to eventually show the government that, hey, I have provided these services, here's the proof. So if I could take a picture, of Podstock for providing seminars, you could use this as proof of use. So that's the main way. You have to use the mark eventually to get the registration. However, the other way is to apply for a registration under intent to use. So intent to use is a type of trademark application that you can use to secure your rights before you render the services, before you go live. So, I've got the best name for my podcast. I'm ready to rock. Here we go. But it's going to take about 6 months before we can really get something recorded and produced and put out. Well, when you got the name, if you want to protect it, you file an intent to use trademark application. So that puts your stake in the ground, puts your property, your stake in the ground. It says, today is the day I own this mark, even though I didn't use it. So then you go, once that's filed, you're covered, assuming you do get the trademark. So then it has to go through. So the process is, I must have skipped it, but so the process is you file for an application. It sits with the government for how long? 10 months. It used to be 6 months, but it sits with the government for 10 months. So your application will sit there while you come up to speed and provide your services, you provide your podcast. Then in 10 months, you'll get a rejection or a notice of allowance. Let's assume you don't get a rejection, you get a notice of allowance. Then the government comes and says, hey, it's time. Show us proof. Are you rendering the services? And I have plenty of clients that, a year goes by and they haven't yet launched the podcast, so we don't have proof. So then you have to get an extension and so on, and eventually when you do render the podcast, you make it live, you show proof, they'll give you the certificate of registration. So it's like this whole long drawn-out process for a name that you thought of, a year ago. And hopefully when the year comes and they allow it, you're still providing the podcast. You didn't move on to some different name. So an intent to use application is the way to go to protect, to protect your name while you get up to speed and produce. A little more about common law trademark rights. They're great. I mean, the law understands common law trademark rights. I've been using this name for my podcast for how long? 6 years, 10 years. I've been using it for 20 years, whatever the case is. If you're using that and you're not registered, you still have a bundle of rights. You can stop others. You can go to court. You can oppose trademark applications for some newcomer who's actually filed, and that could be a problem. A lot of times I'll get that. I'll get the call, well, I've been using it for 6 years. I've been using it for 10 years. Somebody just went and filed. Now I need your help in stopping them. So what's good is, the good to know is that, even if you're not registered, you're providing these services under the name, you've got some rights that you can take to court, some rights that you can use for takedowns, some rights that you can use for opposing someone's trademark application that somebody filed after you. So what happens is, it's not just other podcasts that can block your trademark. It's the same. It's the entertainment industry. They can cause problems. Anybody who has a magazine, a book, a TV show, if they got that name and they're using it first, they can have a problem with you, or vice versa, depending on Who is first? And that's really the question. What decides these trademark disputes in most cases? Let's see. So why register? That's the question. So why do you bother to register a trademark if I have common law rights? Well, the short answer is that it just solves problems, makes things easier, because it's easier to go ahead and register your rights than it is to undo some newcomer who went and filed for rights and it causing problems. So we register for that reason. We also register because it works really well with takedowns with internet service providers, hosting companies, Apple, Google, whoever these hosting companies are. If you have your certificate and you could send them a scanned copy of it and say, look, Apple, I need you to take down XYZ podcast because they have my name. Here's the certificate. Well, they'll respect that, and that's what's good. They will definitely honor your certificate of registration. Now, if you didn't have a registration and you've been using it for all these years and somebody else has the same name and they're rocking their podcast, you send that email at the takedown to Google or to Apple, they're going to drag their feet. You're not going to get anywhere, and you're going to have to use the courts then to undo something like that. So that's why you register. And again, remember, trademark law is very boring. So if anybody has a question, you want to talk, ask, let me know. It helps keep things moving. Got a couple horror stories. You get what happens, just like with any other industry, what happens in podcasts is you launched your brand, everything's going wonderful, and you get a cease and desist letter. And then, you get this nasty gram from law firm of Johnson and Stone, who, you have 10 days to respond, and we want you to make an accounting of all the profits you've made, and we want you to take this down immediately. And it's just an ugly letter, and I get clients who will call, and it happens. So there are tools that you can use to avoid these type of things. And we'll get into that in a little bit more. These trademark oppositions, they're things so that happen when you file your application. When you go ahead and get this thing filed, and you're in and you're moving through the government process, trying to get your extra trademark rights, and you're moving down this path, there's an opposition window, which is like, if I decided to register, time or life, something real well-known or famous, Google, whatever. If you get past the government and it happens, there's a 30-day window where parties who are affected, they're pissed, they want you to stop, they could challenge your application and put the brakes on it. And it's a whole court proceeding that happens within, not in court, but before a trademark board, which is a court within the United States Trademark Office. So there's also lawsuits and injunctions, and they're the uglies and the costlies, and they happen. I found a couple of cases here that explain that and go through it. But anytime you hear the word lawyer, what's going to happen? You're going to spend money, right? You're going to spend a lot of money. If you, and it goes as you go down this list, the amount you spend or you're on the hook for is even more. So it's like, one thing is to register, and to try and avoid these problems, but cease and desist letter. You could respond to it. A lot of times you engage with the lawyer to kind of fix it. Lower cost. Trademark oppositions, big cost. Lawsuits, forget about it. You're spending, 10, 20, 30, 40, 50 and up, depending on how much you love that trademark. So as you go down this list, the costs go up. So do what you can in the beginning to avoid these problems as you go. And it's not just that. It's the fact that you put your life into your brand. You developed your brand, you have the name, you just produced 50 episodes or 20 episodes, whatever. You have your YouTube channel. You have all this other stuff you've done. You've made swag. It's your identity. You have all these internet accounts. And then you have to stop. And you have to rebrand. That's a big thing, too. That's a big cost. And you want to keep that in mind as you go down, this path. So here's an example of the ugliest of the uglies is this outside in podcast versus outside podcast. I think one was a magazine, and they had rights from a magazine, and somebody else came and entered the entertainment realm of podcasting before them using, the word outside, and they love the name, but this magazine loves it more because they've been using it since the 70s. So here they are in court in New Hampshire, fighting it out. What happened, I don't remember, but they spent a lot of money fighting it out. The next one is an interesting horror story in terms of fighting these out, is that you have this Reply All podcast versus, this other Reply All. It was in the federal court in the Southern District of New York. Just ended this spring. It started 7 years earlier. So a 7-year legal proceeding is the ugliest of the ugly. And I'm sure it was some huge company with a large coffer, and and that's on each side, and they really love the name. And I think in the end, they both got to use the name. That's what happens 99% of the time, unless, they're Google and you're little guy. Most of the time, if you're on par relatively, you're going to work out some type of negotiation where you both use the name anyway with some little bits of changes, because you might not in the beginning, but then the punches come, and the cost comes. It's 6 months later and you're still fighting. Eventually you're going to settle and say, look, we can both use the name. You're just going to add something to it. So that's something to watch out for. So here we go. How to minimize trademark infringement. How to minimize these problems. It's just common sense. When you're thinking of your name, you want it to be distinctive. It has something catchy. It's not a common basic term like, it's not, I want the entertainment podcast. I want weekly news podcast. Those are all descriptive type marks that you really can't protect. So you want to add something. What am I going to add? And that's up to you and your imagination. We all know that that's part of the magic, is coming up with the name for your brand. That's the magic. So just think of that. When you use descriptive terms, know that, or generic terms, describe what they are. Just be aware that, they're not very protectable. If you want it, you got to be up and you got to pick something that's going to be catchy. Search. So yeah, Google it. First of all, we know common law use is a problem. So when you come up with a name, don't just check the trademark office. You need to check everywhere. You need to Google it. See who's using it. And it's not just in podcasts, it's in entertainment in general. You know what I mean? I would say that the closer you get, the further away you get from providing content in audio format, the better. But, if there's an influencer out there with the name, there's a YouTube channel out there with a name, there's a television show, radio show, etc. All those things are possibles. And what you want to do is get specific. So if you're filing a trademark application for something and there's some other ones out there, registered or unregistered, you may want to say, well, my podcast, when you apply, it asks you what type of podcast. Well, then it's about, whatever the topic is, cooking. It's about XYZ lifestyle, whatever it is, that's, you want to get really specific, because the more specific you get, the easier it is to kind of find your way around these other podcast brands, especially when we know there's 40-some thousand who have applied. You want to be specific as to your subject matter. At least for the application. It doesn't mean you have to stop. doing, and you can't go outside of that subject matter, but that's what you want to do there. You want to search. Search Google is your friend. The trademark office is your friend. If you just want a name, take a generic term like, daily podcast. Take your first name and your last name and daily podcast. You're going to get yourself a trademark for that. There's some hoops you have to jump through when it's your first and last name, but why not? You could use your first initial, last name, middle name, whatever, but you're going to help distinguish yourself from the others. So you could use generic or descriptive terms, just add a little something to it. The good thing is, if you do go through the trademark process, the good thing is, when you get to the finish line, and it's not when you get your certificate, it's a little bit later, it's actually 5 years later. When you get to there, finish line all the way down here, I'm gonna start over here. So here we are. We're starting out with our trademark application. Got a name. Oh, I got a name. That's great. So I'm all the way down here. All right, let's protect it. So you come down, you got your application. So here we are at the application. You move down the line. Here we march down the line. Government attorney will review it. Yes, no, rejected, big pain, got to fix it, so on. Maybe they allow it. Notice of opposition period, and that's where the others can come out and say, look, I want you to stop. You're not getting that trademark. It's too close to mine. You pass that, I would say 95% of the time. Then, proof of use. Well, we're not ready. We haven't produced. We'll get there and produce, show the proof of use. Yay, we made it. We got our certificate. That's a bundle of rights right there. We've got a bundle of rights. It's different than common law rights, but we have this bundle of rights. Wonderful. The finish line is 5 years later. So you have your certificate. I have my certificate. Yay, you can't use my name. You can't use my name. But they can sue you. They can come after you. They can cancel it. So you want to keep marching down this road until you get to the 5-year mark, and then file this in contestability status. So when you do that, finally, you're protectable. No one can challenge you. You're good in court. So that's what you want to do in an ideal world. But there's a lot that goes on. So one point is, a lot of things come and go. The tides come and go. You start a podcast, it doesn't go anywhere. Are you going to trademark it? Maybe not. So it's understandable that you don't go through the process for everything. But if you know it's going to hit and you got a lot of investment and it's big, you might want to use that process. But I'm not saying use it all the time. Use your common law rights if you have to. So I have 2 more things. So we got final advice about branding, and that is every conversation I have with everyone who calls me who's in trouble and worried and they're picking names and I don't know if it's going to work, have one in your back pocket. Have the second brand ready to rock. You've done all the work. You guys are professionals. You know what you're doing. You're creating content. You know how that works. You know everything, so all you're doing now is just swapping out the name. But you better get the .com. You better get everything else and keep it where? In your back pocket, okay? So that's big. And I like to have 2 or 3, So that's the biggest, another important piece here. So with that said, are there any questions about trademark? Go ahead.
Yeah, so I have a question. So I've started looking into this for my own show. So how much does it cost when you go through a lawyer to be able to trademark? What's like the range that you see for cost? And is it 2 different types of trademarks, streaming and downloading?
It could be, and there's a lot to talk about there, but generally it's about $1,000, okay? But it depends on the number of classes. It depends on a lot of things, depending on whether you have proof of use. There's a lot. And what happens is you're taking you're going on that journey. And a lot of times when you're back here, you should have talked to the lawyer, not when you're all the way down here and you're in big trouble and you're having problems. Because I've been on this road, and lawyers have, over and over. My marks are in the ground because I've been there so many times. I've taken that ship at sea 100 different times, 100 different ways. So a lot of times, it's the best thing to do is check it out here and have someone shepherd you through it. Okay, so that's it about trademarks. I need about 3 minutes to talk about something that I think is more important than, oh, go ahead.
Just a quick back up to what she said. How long will it take from the time how long would it take in terms of time from the time you come up with until you can get the trademark?
That's a good question about timing for trademark applications. Well, it used to be 3 months. You used to be able to file the application, and if you had proof of use, great. It didn't slow it down at all. You have 3 months. The government would examine it. You show proof of use. You get your certificate. You're already here. The problem is they have a huge backlog, and now it's 10 months. 10 months is a long time to wait for a full rejection, okay? So, and that's just the way it is. It's 10 months, 10 plus. You might get your certificate 12, 13, a year and a half. Good question. So this is important here. I think it's almost, if not, it's more important. If I said anything today, I think what you need to know, at least keep this in mind when you're producing content. We're switching gears and talking about copyright law. Copyright law is an area of law that protects the production of content, okay? For you guys, it's a sound recording. And what we have here is this concept of a joint work. And so you have a couple of situations where joint work happens. You've got 4 panelists in front of their mics being recorded, okay? Question.
With Dear Sis podcast, I did both. I did Mine's the Poor Man's Way, and I know a lot of attorneys don't like to bring that up because whatever, but I did do Mine's the Poor Man's Way, and I did trademark Dear Sis. And it was, do you want the explanation? Do you want the quotation? Do you want the question mark? It's very tedious, but I did do it because I knew that my name, as far as Dear Sis is concerned, will take me very far. So I highly encourage it to everybody. But when you don't have any money, do it the poor man's way. Post office, easy, done, 75 cents, whatever the stamp is. And then when you start making some little bit of money, you grinding, then you definitely should trademark. I encourage everybody to do that.
Yeah. One thing, the poor man's way does not work. It is not recognized by law. So let me tell you what the poor man's way is now. Publish content. Take your phone, turn it on yourself, right? Take your phone, turn it on yourself. As soon as you got a great name your YouTube channel, name each video with that name. Hello, this is XYZ podcast. Boom, you've got yourself your date, common law rights. You've set it in stone, and it's on the internet. So that's the way to do it. As soon as you come up with a name, one thing is like, I don't want to put it out there because somebody will take it, but the other, and that's fixed with an intent to use, but the way to fix it is, common law rights. Turn that phone on you. I know it's not going to be the best, it's not going to be super produced or anything, but boom, here it is, and you're going to put your name, your brand, and you're going to lock it up. That's how you begin common law rights, because you don't want to get into a situation where, I used it first. Well, I thought about it first. No, I used it first. So that's kind of where we're at with that. So that's good, and that's a great point of clarification. Okay, so back to here, copyright law. You have, I would think it's ubiquitous. Everybody does it. You've got a couple of hosts engaging with each other. They're talking, you're talking, you got an interviewee maybe. Who owns copyright? This is just something to think about. I mean, there are answers, and it could come down, because it's an area of law, it could come down one way or the other. But when you've got 2 or 3 hosts all yucking it up together, creating their content, and their record button's going, you've got yourself a joint work of authorship. I don't care if you just met them. I don't care if you paid for everything. They came up and spoke into that microphone and made part of this project. And that's where you can have some issues. So just, it's broken down a little bit, but the law kind of says something like a joint work prepared by more than one author, where their contributions are merged into an inseparable or interdependent parts of a unitary whole. I'm going to say that any podcast where you have several panelists up there, even an interviewee, you've got yourself a joint work. And what does that mean? That's a problem. It's not a problem, but it creates rights for everybody. And let me just get to that. So what are the rights? Each joint author has the right to use and license the work as they wish. So if it's your show and you brought somebody up there without a waiver or any type of written document, they are co-owners of this finished product, okay? They have a right to use and they can license it all they want, give it to anybody to use. So that's huge. And I think this is the most important point of everything I've talked about. And you know, the other one is there's an obligation to account for the other. So if you're making money as a show and you brought somebody on, that somebody could go here and give you huge problems. So I think that's a huge point about copyright law. How to avoid it? Put something in writing, make them sign something. I know it's a problem when you bring up a guest and you want them to come and contribute, whether it's over the phone or whatever. You want them, come, but you gotta sign this. Well, guess what? Yeah, they gotta sign it. It doesn't have to be ugly, like you get no rights whatsoever. I mean, it could be something like you get some rights, but let's make clear that I own it. You could use it, let's make clear that I own it. Or, so there's ways to fix it. And that's what's going on there. Use the agreement before, get an agreement, use an agreement, some type of understanding. And then ideally, you want to sign it before they get there and put the content on the recording. Because when they're gone, they're not signing anything. Whether you make money or not, you know, as the fame goes up, they left the door. They're not, I'm signing this, I'm not signing that. So this is huge. This joint work thing, it could fall on either side of the law. I think that in many cases, courts will find it's a joint work. All four are authors of that joint work. It's been recorded, boom. Okay, so that's what you got to look out for. So my take-home point is watch out for joint works. This content is available right here, esquiretrademarks.com/podcast if you want some of that info. Okay, people, any questions?
I just got one question in regards to the last portion you mentioned about the copyright avoidance. Is that agreement, could that agreement be a verbal agreement that's broadcasted prior to the person proceeding with the show? That agreement? Yeah,
so the question, these agreements about copyright joint work, the answer, you're asking a lawyer, get it in writing. And can they be verbal? The courts are mostly like, no, for assignments of trademark rights. So it used to be pen on ink, and you might be able to get with like an Adobe or an electronic sign, but have it signed. Don't get into that. Because when you get into the verbals, even if it's recorded, it might not hang its hat in the law. Any other questions? All right, thank you, everybody. Esquire Trademarks.
Charles Riddle, let him hear it. Charles, a lot of information.